we're going to talk about some confusing terms in the VA process. If anyone has had even 5 minutes of exposure to the VA claims and appeals process, you know that there's some really confusing terms, phrases, terms of art that VA uses. We picked a few that we want to quickly walk through, and we're hoping that this demystifies and kind of clears up some of the legal jargon that can come along with this process. Ethan, let's start with what nexus means.
Nexus. So if you've dealt with the VA at all in the claims process, you might have seen them say you didn't prove a nexus or we need to show a nexus. A nexus just means a medical link between a disability and a cause. So some sort of medical connection. So as we mentioned in our earlier video, service connection requires 3 things. For direct service connection, a current disability, an in-service event, and then the nexus, the connection between those 2 things. This is almost always going to be proven through a medical opinion. So laypersons don't have the necessary training in VA's eyes to say what caused their disability. So it's important to get medical language from a private doctor or a VA examiner. What VA is looking for is whether the condition was at least as likely as not caused by service or another service-connected disability, which roughly translates to over 50% likely. Court cases like Shedden v. Principi have made clear that you can't get service connection without a nexus. It's an essential part of that claim. And the more specific your nexus evidence is to your own disability, as opposed to general medical articles, the more helpful it is to prove your claim.
Great. And even though nexus is hugely important, there's also the idea of a presumption. VA has presumptive rules. You may have seen that term. What does presumption actually mean, and how does it apply to my claim or appeal? A presumption is when the law presumes that a fact is true without requiring the claimant to produce any evidence as to that fact. So we've talked about presumptions in a lot of our materials that we have online. The most common one that I always think of is herbicide exposure is presumed if you were in certain places of service with certain dates. These are all defined by regulation. If you want to look more at regulations that talk about presumptions, because there are many, and they tend to be pretty nuanced, you might want to look at 38 CFR 3.307 and 3.309. Basically, so a presumption is a shortcut that's built into the law. Ethan talked a minute ago about nexus. Well, the burden to demonstrate a nexus is actually relieved if there's a presumption that presumes that a certain condition is related to radiation exposure or herbicide exposure, or if you need to demonstrate exposure, the law might take care of that by saying that your places and times of service are consistent with such exposure that the law will presume it. So presumptions really do help claimants relieve the burden of having to prove certain facts, but it is important to read the specific regulatory provisions because they can be pretty nuanced, limited. Hopefully that's helpful, though. It's kind of saying there's more information that you need to get. But if you see VA applying a presumption or a presumptive rule, that's the essence of what that means.
Yeah, so next up is actually going to be the word benefit, which funnily enough is one of the more confusing terms in VA's world. People hear the term VA benefits and they kind of think of a reward for good behavior or good service, or some sort of additional benefit for all veterans, regardless of their disabilities or medical history. They might also think it's like charity or a handout or, some sort of social benefit or reward. Really, that's not what VA benefits are at all. It's kind of a misunderstanding of how VA thinks about their own benefits. And it can actually make veterans less likely to file claims because they think there's something shameful about it. Or feel like they're asking for something they didn't earn, a handout. Really, the idea of VA's benefits, disability benefits, is to compensate veterans for what they call loss of earning capacity. So Congress recognized that when you have an illness or disability because of service, it makes it harder to work. It makes it harder to earn money and earn a living. So it's baked directly into the statute. It's 38 U.S.C. 1110, and then VA's own ratings, that the percentages they assigned are to compensate you for your loss of earning capacity, your lessened ability to earn a living. In that sense, VA benefits are probably closer to workers' compensation benefits after an injury on the job. They're really meant to compensate you for those service injuries and problems that just make it difficult to function in day-to-day life.
That's a great segue into the next term on our list, which is the rating schedule. VA has a massive series of regulations in the Code of Federal Regulations that we've talked about a lot. 4-point, insert your regulation here. There's a whole series of regulations that govern the different types of ratings that VA will assign based on a service-connected disability or condition and how it manifests. So as Ethan mentioned, the point of VA benefits is to compensate individuals for loss of earning capacity and the functional impact that their service-related disabilities cause. And the rating schedule defines exactly how each condition should be rated individually based on how different conditions manifest as symptoms. So for example, the psychiatric regulations or rating criteria in the rating schedule talk about a series of symptoms or impairments associated with a 0, 10, 30, 50, 70% rating. That same scheme applies for all of the different conditions that veterans can be service-connected for. So if you have questions or concerns about how VA is rating the individual disabilities that you have, the rating schedule is a great place to look to see what are the criteria for the higher rating or the lower rating. Why does VA think that my symptoms are consistent with this rating? The rating schedule is probably going to tell you exactly how VA rates the conditions for which you're getting service-connected benefits.
Yeah, and those percentages are assigned based on what VA thinks is kind of the average loss of earning capacity. So a 20% for a back condition is saying that generally, if you have these back symptoms, your ability to work is reduced by about 20%.
Exactly. And that can be a tricky concept because I think there's a lot of subjective experience of symptoms and impairments. There's things beyond occupational impairment that are relevant to people, humans living with medical conditions and disabilities. It's more than just can they show up to work.
Right.
But VA does anchor the scheme of regulations and the scheme of ratings based on that sort of North Star of impairment and earning capacity.
Yeah. So next up is the bilateral factor. You might see this on a rating decision or VA list of your code sheet, your current disability. The bilateral factor is something VA applies when both sides of your body are affected by a disability. So if both legs, both arms are impaired, both feet, VA is supposed to add an extra percentage to kind of reflect the added difficulty of both sides of your body being impaired. That comes from 38 CFR 4.26. Ideally, this is supposed to boost your rating automatically, and VA should do this without the veteran even needing to request it. But it does get messed up sometimes. They might forget to apply it. It doesn't create a new rating, but it does help veterans get to a higher combined percentage when they have both sides of their body impaired.
Yes. The next term we have is pyramiding. Maybe you've heard of this one. Sounds a little weird. Essentially, pyramiding is VA's rule that prevents paying for the same manifestation of symptoms twice. So there's a regulation at 38 CFR 4.14. It says that VA cannot compensate the same functional impairment under multiple diagnostic codes. So the key with pyramiding, if you have a decision that says that to assign increased compensation would result in pyramiding, the key is that VA will not pay in benefits for the same manifestation, even if the injuries involved are different. So this is a little complicated. I think a good example comes from the seminal court case on this issue, which is Esteban v. Brown. In that case, Mr. Esteban had a facial injury in service. It resulted in a painful scar. It resulted in disfigurement, and it also resulted in difficulty chewing because of muscle damage. So that's one injury that's causing multiple different manifestations. And when he applied for benefits, VA did not compensate him for those 3 different distinct manifestations of his facial injury. So he appealed to court, something that we have to do all the time here. And the court clarified that because the one injury resulted in 3 distinct manifestations of symptoms, a painful scar, disfigurement, and difficulty chewing, it would not result in pyramiding, which is like the forbidden thing, to pay him separately for those distinct manifestations. So if you have an issue where VA is saying that compensation would result in pyramiding, you want to focus on the distinct ways that the injury or condition affects distinct bodily functions, different kinds of earning capacity impairment, like Ethan was mentioning. And that's the best way to look at that situation if VA thinks that they're assigning duplicative compensation. It won't be duplicative if there are distinct manifestations that you can point to.
Right. So next up is VA math. This is probably one of the more complicated areas of VA law in general. Veterans often ask why, if they have two conditions rated at 50%, they're not getting paid at a 100% combined rate. And the answer is VA math. So VA has its own formula and ratings table in 38 CFR 4.25, and it adds up your ratings differently than just 50 plus 50 equals 100. Each new rating is basically applied to what they consider left of your earning capacity that is not already being compensated for. So bear with me, this is kind of a long walk, but if you are rated combined at 90%, you might think, oh, if I just get one more rating at 10%, they'll be paying me at 100. Actually, you would need something at 50% or more because they are calculating that additional bump based off that remaining 10% of your earning capacity. They need to show that you're over half of that remaining 10% is impaired to pay you for 100. It's very complicated. I don't think there's hardly anyone even who has been practicing veterans law for a really long time who doesn't need to use our ratings calculator or some resource to do this. It's not just a straightforward formula. I think it's like algorithmic. They have their own system to do this. It's counterintuitive and it can be frustrating, but it is required by regulation. So understanding this just helps you set realistic expectations for how your compensation can change. And it can help you kind of spot calculation errors if you feel VA is not paying you correctly. It's just important to keep in mind that it's not simple addition. There is a lot more complicated math going on there. And then the higher your combined percentage already is, the higher ratings you will need to actually increase it.
Exactly. There is a chart in the regulations where you can, I've done this before, but not very often.
No.
There's a chart where you can line up your current ratings and then what additional ratings would increase your compensation to the next 10-point scheduler criteria. But as Ethan mentioned, we have a calculator. There's a few of these online.
Yeah.
And we recommend using that if you are curious about why a rating percentage increase, maybe for one condition, did not result in a total combined rating increase, because the answer is going to be VA math.
Yeah.
Next two terms, severance and reduction. These are similar, so we'll handle them at the same time. A reduction is when VA institutes a process to reduce a service-connected disability rating that's in place. Sometimes VA will send claimants to exams. Those exams will reveal that there's been some improvement in a condition, and usually incorrectly, VA will propose to reduce that person's rating. A severance is when VA wants to remove service connection for a condition entirely. So a reduction still keeps service connection intact, but a severance is effectively VA saying service connection is not in order and should not have been granted in the first place. These are very tricky, frustrating, and really difficult situations we find in our practice that veterans find themselves in if VA is going through the process of reducing a rating or severing service connection. Of course, there are some conditions that by their nature are expected to improve, such as sometimes cancers with effective treatment. But there's a lot of other conditions that only progressively worsen over time, generally speaking. And so getting a reduction for those ratings can be really frustrating. So we recommend reading the notice letters for sure, very carefully. VA has a series of due process rules that they need to follow. They need to propose to make a reduction or a severance if it would impact your monthly compensation. They need to allow you a period of time within which to respond. You can request a hearing if you'd like. You can submit evidence to rebut what VA is saying as the basis for the reduction or the severance. So pay attention to the paperwork in those cases. But yeah, if you're getting papers that talk about reduction or severance, that's the story. And I think the biggest takeaway is just to remember that due process applies and you have an opportunity to respond.
For sure. So lastly, we have functional loss. So functional loss is most important with orthopedic or musculoskeletal conditions. The regulations basically say that VA has to consider not just the range of motion results, but the way that these conditions impact your daily functioning and your ability to actually use your body part, including during flare-ups. The court really reinforced this in DeLuca v. Brown and some other cases since that time. The gist is that the range of motion numbers when you get tested for your joint disability is not the whole story. You might still have decent range of motion, but your knee limits your ability to walk or stand, for example. Your back makes it really hard to bend over. these are impairments to your ability to use your body part in daily life, and VA has to consider that evidence when they're rating your condition, and not just purely rely on those range of motion numbers.
Great. So these are terms that show up all the time. We see them all the time in our job, and veterans out there who are going through the appeals process might see confusing terms like these. We hope that this helps to clarify some of what you're seeing. And of course, we always recommend that if you have residual questions that you feel like you can't answer, definitely speak with an accredited representative who can help you navigate the legal jargon that kind of comes along with this process.
Mm-hmm.